everyone, and welcome to Thursday Talks with Chugh. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chugh, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Diya Mathews and senior legal consultant Kaveri Vijay from our Edison, New Jersey and New York office. Hi there, Diya and Kaveri, and welcome. For today's topic, we will be talking about decoding investment agreements. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so please comment your questions below or email us anytime at info@chugh.com. We would love to help you out. Let's get right into it. Diya, can you tell us what is an investment agreement?
Sure, and thanks for having us, Ariana. So, an investment agreement is basically any type of agreement by which an investor can have an ownership stake in a business. Now, you could have different structures for this. Primarily, it would be equity, or it could even be done through preferred stock, depending on what the parties have commercially agreed on between themselves. The percentage of equity that the investor holds in the company will determine the investor's management and control rights. And the parties will usually also choose to have an investment agreement that defines the rights and obligations of the investor, the company, and all the shareholders of the company. So that's basically a little bit about an investment agreement.
Thank you for clarifying that. So essentially, an investment agreement serves as a formal contract between investors and the companies delineating ownership stakes and operational parameters. I appreciate you sharing that with us. So who are the parties involved in an investment agreement?
Right. So there would be the person making the investment. That's the investor. The entity receiving the investment would be usually defined as the recipient company, and then there would be other shareholders as well. Now, keep in mind that the investor can be an individual or an entity, a corporate entity, and that investor will become a shareholder in the company once the investment is completed.
Understood. So it's important to acknowledge not only the investor and the company, but also the collective of shareholders, as their alignment ensures the success and stability of the venture. So Kaveri, can you tell us what types of investments can be covered by an investment agreement?
Apologies, I was on mute. So thank you for having us here, Ariana. Yes, good to have a discussion on this. So in a company, basically investments are brought in for working capital, basically for running the funds of the company, operating, and for the management eventually that is used for managing the operations of the company. So basically, how we can get capital in the company through investments is either we get it through equity, that is the clearest way, or the most popular one. And also at times the structure revolves around debt. So the investments then and the structuring of the investments will revolve around these two aspects, whether it would be an investment through equity, as they explained, then this investor gets shareholding in the company and gets an equity stake in the company. And depending on the commercials and the investment value, he will get the shareholding, whether he would come in as a majority shareholder or he would come as a minority stakeholder, or it could in a JV. Some at times it is generally in a JV you are a 50-50 partner. So the investment generally determines the shareholding stake and the controlling and power rights which are related with the investment. Debt structuring is also there, but generally not a very common route which is taken. Equity is more preferred, so we can concentrate on that part for now.
I appreciate your insight on that. So while equity transactions are predominant, the flexibility of investment agreements can accommodate various structures, such as the specific needs of stakeholders. So Kaveri, what steps should I take before signing an investment agreement? What do I need to know?
Yeah, this is a good question and a relevant one, because often what happens is towards the end, to avoid any confusion or ambiguity in the terms, it is always better to start from scratch from the right place. So at the beginning itself, when the parties are firming up their terms and conditions and the commercials, it is always good to draw out a term sheet to have clarity of the outline and framework of the investment, what rights both parties will have, what is the investment value, and other important terms like what would be the exit rights available, what would be the additional funding requirements of the company. So a term sheet generally gives a outline, a nutshell, perspective of what all will be covered in the main investment agreement. And then it is more clear while the parties are negotiating the terms of the agreement that they know that this was already discussed, and then we don't get to wavered or then get into complexities and confusions later. So that is a good point. Second, as an investor, when you're coming in a company, whether it is for an acquisition, it is just for a joint venture, it is always good to do a diligence on the target company, to get a sound sense for your investment's worth. This also lets you help along with the assets what the liabilities of the company would be. And the liabilities also include any kind of litigations the company is pending on, or what are the outstandings to any clients, any vendors, any we have some compliance issues which were not which are still pending. So these are the aspects which the investor will get better clarity on. So at this stage, I think even before you start negotiating or drafting an investment agreement, it is always advisable to have a term sheet drawn out to give an outline, followed by a diligence. If the company has been in operations for a while, it's always recommended. But if it's a fairly new company, say 1 year old, no operations as such, and the parties have the comfort with each other, sometimes at times parties do skip this step. But for a long-term perspective and going forward, diligence will always help, especially if the company's been in business for a while. Yeah, so that is there. And then when you're coming, these are the pre-investment agreement steps that we are talking about. And then when we are drafting the investment agreement itself, we need to be very about the rights of the investor vis-a-vis the existing shareholders in the company. All three are separate parties and will have their own rights and obligations. So, of course, as attorneys and as the party itself, they would have to understand who they have to protect their own client interests, but also work towards facilitating the deal, right? So, in that scenario, from an investor perspective, when they are putting in the money, they want to show ensure that they're insulated from any kind of liabilities, whether it could be monetary or in terms of compliances or litigations. So they need protections against that. Indemnity provisions should be in their favor because of the investment they have made. If anything goes wrong, they lose all that investment, right? In terms of existing shareholders, they need to know if they're still in the company, their ownership is still protected. They cannot be ousted out of the company. Any exit rights could be drafted in such a way that either if the investor is moving out of the company, they get the first offer for those shares. And likewise, if they want to exit out, they could offer their shares to the remaining shareholders and then leave the company. So these are the kind of structures that we need to keep in mind while drafting the investment agreement and pre-investment agreement.
Wow, those were all such great points. Thank you so much for highlighting the pre-signing considerations. And it sounds like conducting thorough due diligence and incorporating robust indemnity clauses helps to safeguard the interests of both parties involved. So, Kaveri, what happens if the company fails to meet its obligations under the investment agreement? Are there any consequences?
So, how the investment agreement works is unlike a commercial contract, where there is a very defined kind of duties and, we know there's a scope of work. There is no scope of work per se because as Dia mentioned earlier, this is more like an ownership title in a company, right? You get title in company, like in terms of property, you would get title. So this is title to your shares in that company. So you own that property, that's shares. So what happens in terms of an investment agreement? So when you're going forward, you will have to keep understanding that the terms of the investment agreement are drafted in such a way that basically termination will not be particularly coming into effect because there is no service per se being given, or a bad default in service can just trigger termination. But there are exit rights for shareholders. Say, because I'm holding these shares and tomorrow I want to exit the company, then how can I get that exit from the company? So there are processes and procedures put down there. There are variations of these processes, and and different forms of exits exist. So both ways we have to see from the perspective of majority shareholders and minority shareholders, right? But giving it to generally in a nutshell, it is to be done in an equitable way that it's fair to both sides. So generally, the general clause would be that any party, when they're wanting to sell their shares and exit the company, the other shareholders have a first preemptive right to those shares, right? And post that, if the process for that is completed, they can exit the company. So that is one way. This is generally you would find in share purchase agreements, or like agreements in acquisitions where the investor has come in, acquired a specific entity, equity stake in the company where it is less than 100%. So the remaining shareholders still remain. However, in a different kind of scenario, say it's a joint venture where a new entity is formed and the investor and another partner has joint venture partner come in, and they both have infused 50-50, then for a project, to undertake a project, in that case, the grounds for termination could be spelled out, in the sense it could be linked to the project itself. If the project for some reason cannot be completed for which the company or the JV was formed, then that could be a ground of termination. Or say there is funding issues, or there are resource issues, or the parties feel that they cannot work together. So in that scenario, then there could be a ground that they agree to terminate the investment in the joint venture itself. So we have to first see what structure we are in of the investment. And according to that, then the exit or the termination will have to be drafted.
Understood. So it's imperative to have recourse mechanisms in place. I appreciate you sharing all of that with us. For everyone who's tuning in, just a quick disclaimer, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions, please comment them below or email us at info@chugh.com so we can help you out. Now, Dia, can you tell us, can an investment agreement be terminated early? Is this allowed?
So the Ariana, the response to that is actually it depends, because it depends on the kind of agreement, right? In a share purchase agreement, typically once the investment is done, the obligations under the share purchase agreement come to an end. So once the purchase consideration is paid at the time of closing, then the purpose of the agreement is served, and that's ended. So there's really no termination after that. But in other agreements, typically when you have a joint venture agreement and there are two parties collaborating together for future work, right? Then we could discuss termination, because if the project that the JV is working on is no longer feasible to be carried forward, or if the parties agree that they would no longer be able to work together, then they could terminate the JV and the agreement at that point. So with joint ventures, there'll typically be more grounds, because the investment tends to be the working capital in the company. And so you can terminate that arrangement if the parties wish. But once the investor has come in as a shareholder in the company and wants to terminate his shareholding in the particular entity, then at that stage, termination of the shareholding can be done by exercising the exit rights, where he can either sell the shares to existing shareholders or to a third party. And normally this would be laid out in the bylaws or in the investment agreement.
Wonderful. I appreciate those insights. So I have a follow-up question for you on that. Can an investment agreement be modified after it's been signed?
Yes. So again, going back to basic contract law, if the parties agree, then they can amend. Usually there'll be an amendment clause. And so if there is mutual agreement, then they can modify the agreement.
Understood. Thanks for sharing that info. So are there any regulatory or compliance issues I should know when I'm entering an investment agreement?
100%. It's always best to get proper legal advice. So capital structuring requirements will usually require board resolutions, compliance with bylaws, and there might even be filings needed with the state, with the Secretary of State or with the Corporations Division. One other important thing to look at would be also tax repercussions. So always get good tax advice when you enter into an investment agreement.
Thank you for covering all of that for us. Kaveri, are there any restrictions on transferring my investment interest outlined in the agreement? Can you share some insight on that for us?
Yeah. So transfer restrictions ideally in an investment agreement do form part because we don't want shareholders once they come in to just freely walk out. That can disturb the whole management and operation of the company. So for stability, we would want all the shareholders, and that's why a lot of shareholders even have lock-in periods. That for since the closing, since the signing of the agreement, say for a year, or at least 3 years, none of the shareholders will exit the company so that that stability can be maintained through their presence in the company, right? But however, if they do want to like terminate the shareholding or do not wish to continue with the company, then of course every well drafted shareholder agreement should mention about exit rights and would give those rights to shareholders whether they can first sell their shares to the existing shareholders in case the process with the existing shareholders is not amicable in terms of the value or number of shares or the liquidity of the company itself, then in that case, those same shares could be offered to third parties, right? And at times there are carve outs in these exit clauses that when we are selling these shares to some third parties, they should not be competitors of the company, or there should be some kind of classification given for these new shareholders, the third parties, so that once, because anybody who's coming in the company would then be the new shareholder in the company and will also have participation in the management and operation. So we don't want a working partner with whom we have difficulty and wavelength match is a mismatch. So that's why these clauses are there. There is a financial implication because, of course, there's a pricing guideline, and the pricing has to be determined at which they can exit because the other shareholders will have to pay that price. If the company is buying that share back, the liquidity of the company will also have to be seen at that stage. But along the financial parameters, the operations of the company are also important because we don't want disturbance and somebody at the board level who's always trying to create a ruckus at the board. So we want peace, in terms of the functioning of the company and also looking at the finances. So that's how an exit can happen, but these are the factors to consider.
I see. So it sounds like it's crucial to acknowledge the restrictions on share transfers to maintain the integrity of ownership structures and corporate governance. So, Kaveri, one more question for you. Do you have any advice for anyone who's thinking of going through this process? What should they keep in mind? Where should they do their research? Who should they speak to? Any final words of wisdom for anyone who's considering an investment agreement and not really sure where to begin?
Yeah, it is always advisable first to at least, do your own research if you can, understand the subject. Don't sign something blindly because I know a lot of times what we are doing is in terms of investments, generally the companies who are seeking investments for liquidity, they want to just go and sign agreements so that the money just comes in. And we feel all these terms and the drafting and the review of these terms is not very important as long as the monies come in and there cannot be any issue. But to be on the safer side, before you enter into any new transaction or a business relationship, like a business relationship, it is important to first, at least before signing anything, having it vetted once from somebody who can give you legal advice on it, because at times we sign up, the understanding is of the terms is very different. Sometimes what we have signed up is that we may just lose the entire shareholding in the company even though we were a majority shareholder, because the terms, the way they were structured were, and the investor has more financial power to buy you out. So if you want protection, if you don't want to lose ownership in your company, or for that matter assets like intellectual property, in a lot of companies which have IT as the principal business service, gaining ownership in all those intellectual property products will make you lose all your value of the company. So irrespective, shares are there, but the assets also go along a long way. So these are the protections you want, that you are not diluted in the company, or your shareholding is not diluted, or you cannot be ousted out of the company without your will. Or on the other hand, one also has to see from both angles at the management and control of the company. So say the investor is coming in, how much of the board control will the investor keep, and how much free hand one has. At the same time, the investor needs protections for the investment. So what is crucial? We have monetary thresholds. At times, we include them through affirmative vote rights, saying that if the transaction, say, cross $10,000, for example, the investor's approval has to be taken. Anything below that is ordinary course of business, and we don't need to go to the investor for every board resolution to be approved through that affirmative vote. So there's a balance that can be created to protect all parties' interest in an investment agreement, but it is important to be aware about it. And before signing, it is all at least recommended that you consult somebody who can give you legal advice on it, or meet some people who have gone through this investment process before and who can guide you. Yeah.
Wonderful insights, Kaveri. Thank you so much for sharing that. For everyone who is watching, yes, great points. If you have questions, we are a full-service legal and accounting firm. Please reach out to us if you have any questions on legal or accounting matters. We would love to help you out. I appreciate your insights, Kaveri, and your time, and thank you so much, Diya. That is all we have time for today, so this does bring us to the end of our conversation. Thank you so much, everyone, for joining us today. Please let us know what topic you'd like to see next, and please follow us and like our YouTube, LinkedIn, and Facebook pages. To stay up to date, subscribe, turn on the notification bell, and if you have any other questions or suggestions, please send us an email anytime at info@chugh.com, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you so much, everyone, for joining us today. Thank you, Kaveri, and thank you so much, Diya.